Lawrence Tribe is the Carl M. Loeb University Professor of Constitutional Law Emeritus at Harvard University and considered one of the nation's foremost scholars on constitutional law. He has argued before the Supreme Court a total of 35 times. He and former federal judge J. Michael Luttig have recently argued that Donald Trump should be ineligible to be President of the United States because of a clause in the 14th Amendment. Professor Lawrence Tribe, you're a longtime professor of law at Harvard Law School. It's great to see you again. And
Great
we're
to
here
see
to
you
talk,
too.
thank you. We're here to talk about the 14th Amendment. And I know you and Judge J. Michael Luttig, who is a former federal judge on the U.S. Court of Appeals for the Fourth Circuit, believe that Section 3 of the 14th Amendment effectively prohibits Donald Trump from ever being president again. Can you explain in simple terms how you've come to that conclusion?
Sure. Both Judge Luttig and I have studied the 14th Amendment for a very long time. I've been teaching about it for 50 years, and it is one of the most important parts of the Constitution. The 14th Amendment is the part of the Constitution that basically, after the Civil War, said that states cannot violate certain rights on the part of their citizens. But it also said in Section 3 that anyone who takes an oath to support or defend the U.S. Constitution as an officer under the United States and who then engages in insurrection or rebellion against the Constitution can never again hold any office. It's very straightforward. We've never before had a president who, at least apparently, tried to turn the Constitution upside down by violating the provision that says if you lose a presidential election, you leave. You don't try to hold on. You don't, among other things, have fake electoral slates or rile up a mob to sack the Capitol during the time that they are officially counting the electoral votes. And yet that is what it looks like Donald Trump did. So Judge Luttig and I concluded fairly simply that this basic protection of democracy, the provision that says you're not eligible for another bite at the apple if you try to crush it the first time, that applies to Donald Trump. And there are lawsuits all over the country making that argument. One or another of them is bound to make it all the way to the US Supreme Court quite soon, and then we'll have a definitive answer. Neither Judge Luttig nor I pretends to predict what a court with 3 Trump appointees and some other very, very conservative members who are conservative, in my view, in name only. They're really quite radical. We're not predicting what they will do, but we believe the Constitution contains this very important protection of democracy. So that's the story.
I understand this issue was being considered in both Minnesota and Michigan, and judges in both of those states, Larry, said that the 14th Amendment would not preclude Donald Trump from being on the ballot in 2024. Colorado is now considering that same issue. What was your reaction about the findings in Minnesota and Michigan?
It really wasn't too surprising because the state laws in Minnesota and Michigan make it much more difficult to take someone who is disqualified from the presidency and prevent that person from at least running in the primary. The state that says we're not going to run somebody in the primary if they're not qualified to hold the office is Colorado. And there was a week-long trial in Colorado. The verdict will be rendered by Judge Wallace either tonight, Thursday night, or Friday night, November 17th. It's very specific, and whichever way she goes, that is, whichever way Judge Sarah Wallace decides, the losing party goes straight to the Colorado Supreme Court with a brief that's due Monday morning, November 20th. That's the case that I think we really need to watch.
One thing that I don't understand is there is a federal trial happening in Washington, D.C., surrounding these same issues, Donald Trump's role in what happened on January 6th. How does that play into the legal process in terms of his ability to run for office again?
The federal criminal trial, both the one in DC, which is going to begin um, actually on March 4th with Judge Tanya Chutkan presiding, and the federal criminal trial in Miami, presided over by Judge Cannon, and the state criminal trials are completely unrelated to this. This is a provision that is not triggered by a civil or criminal verdict. It basically says we're not trying to punish someone through this provision. We're simply trying to take them out of the running. Once you have taken an oath to the US Constitution for an office under the United States, if you then engage in an insurrection, and the definition of insurrection may be different in this context from what it is in the criminal context, once you engage in an attempt to overturn the Constitution, you can't hold office again. So this does not depend on a conviction. In fact, one of the reasons that the 14th Amendment included this special protection against insurrectionists and rebels against the Constitution was the thought that the criminal process might not work, that in fact the federal government might be in the hands of the insurrectionists, as in fact happened after Lincoln's assassination, when Andrew Johnson, who was very sympathetic with the Confederacy, became president. He made it clear that he would not prosecute people who tried to overturn the Constitution on behalf of the Confederacy, and that he would in fact pardon anyone who was convicted. So this has got nothing to do with whether Donald Trump will or will not go to jail as a result of the federal criminal trial that you're referring to in the District of Columbia.
At the same time, it's my understanding that Donald Trump and his team of lawyers will say he did not instigate an insurrection, that he was merely telling people to, make their feelings known, et cetera, and it was not his intent to do that. So it might be in the eye of the beholder, right? In terms of whether or not he did or didn't violate this statute in the 14th Amendment.
Well, it's not in the eye of the defendant or in the eye of the objector. It's in the eye of the judge. And judges often have to make difficult decisions about who is telling the truth and what actually happened. In this case, there was a full trial for a whole week in Colorado, all day, every day, pretty much. And evidence was put on that related not only to the final violence on January 6th, but to events that go all the way back to the election. From the very moment of the election, there is evidence, very strong evidence, that Donald Trump said, "I'm not leaving. I don't care who says I lost. I don't admit that I lost. I think the election was stolen." And he was willing to do whatever it took. The evidence over the past week in Colorado was very strong that he was directly involved in the fake electoral slates. And in addition to that, that he in fact did rile up the mob and very occasionally said, "Oh, be peaceful." But on the other hand, he did everything he could to make sure they wouldn't be peaceful. But we will know what the trial judge finds based on all of the evidence. And Donald Trump's team had ample opportunity to put in evidence exactly trying to prove what you claim. He could have testified himself. It's a civil proceeding. He could have testified. He chose not to. So if the judge finds on the basis of the facts before her that he in fact did engage in or give aid and comfort to, which is also language in the Constitution, an insurrection or rebellion against the Constitution, the fact that Donald Trump says, I don't admit it. It's not true. That's just his opinion. And a judge's decision is going to be appealed to the Supreme Court of Colorado, and eventually it'll get to the US Supreme Court. But the fact that there are different ways of looking at these events doesn't make it any different from what the framers of the 14th Amendment knew would happen. Of course, after the Civil War, it was a little bit easier to tell who was in the Confederacy and who wasn't.
Can we go back to the historical reasons for Section 3 of the 14th Amendment? Because it had to do with the secessionists during the Civil War rejoining the government, right?
Well, that was only the immediate occasion. The secessionists, the people who tried to tear the Union apart horizontally, basically, they couldn't come back in unless 2/3 of the House and 2/3 of the Senate basically pardoned them, absolved them. That's a provision of the 14th Amendment. You can convince 2/3 of both houses that you should be allowed to play a role in government again. You could. But there was a lot of debate over whether this was a one-time only provision or whether it would stay in place in the event that we have a future revolution against the Constitution, future rebellion. As it happens, we ended up having a vertical rebellion. When I say vertical, I mean that the process through time by which one president hands over power to the next when someone else wins, that process is as basic to holding the Union together as is the horizontal process that sticks the states into a union. This was not a secession by the president, but an interruption, a deliberate interruption of the peaceful transfer of power. And there is no argument that anyone has made that's convincing to any lawyer that says that the 14th Amendment only deals with secession from the Union. It deals with any insurrection or rebellion against the Constitution. And the Constitution can fall apart along two, at least, different axes. It can fall apart if states pull apart and leave